Hello neighbor, I'm Robert Burns, and it's time for installment 4 of me sounding off on our illustrious attorney James D. Buddy Caldwell. If you will recall, when we've wrapped up our third segment, we had established pretty clearly that Attorney General Caldwell's office had engaged in what Mike McKay, I believe correctly so, characterized as, quote, outrageous witness tampering, unquote. And we provided you with a pretty compelling evidence with regard to Steve Smith, aka John Canigo, the basic informant here, if you will, the disgruntled employee who, quote, blew the whistle, unquote, on CNSI, an action which I'm sure he would live to regret. And probably does regret at this point because, as I mentioned to you as we wrapped up segment 3, he has now been on the receiving end of a $30 million lawsuit from CNSI as a result of having violated the fiduciary obligations he had under his employment agreement when he fired off said email to Jeffrey Branch at Medicaid Services, who then forwarded it on to Attorney General Buddy Caldwell's office and got us to where we are today. All right, as you might imagine, the strong accusations of witness tampering is something that the court would want to address. And I'll again refer you to Marcia Schuler, who is an excellent journalist, and she provided an article. We're going to give you the link for the article at which David Caldwell did have to respond to Judge Kelly with regard to this witness tampering. And that'll be the very first link that you'll see below this video. If you'll go to the 4th paragraph from the bottom, you'll see that David Caldwell basically says, hey, we didn't do anything wrong. And I would submit to you that that's a big part of the problem. Their belief that they didn't do anything wrong. Okay. Now he followed that up by saying we're entitled to confer with our witness, and certainly they are. But as any decent lawyer would tell you, I mean, I have been in court where when they broke for lunch, an attorney came back and saw the consultation with the client, objected to the judge, and the judge said, I'll hold you in contempt. Now, so common sense would dictate to you that you don't do this sort of thing. All right, so why would presumably, well-informed attorneys that are very capable, we would hope, the Attorney General's office, why would they go to such lengths? And I would submit to you that they went to such lengths to engage in this witness tampering, and I might add evidence tampering, because the altered Canigo report, which Steve Smith said had tons of stuff in there he didn't say, and that is also not accurate, okay? Wanted to clarify the timeline. They were so desperate to try to instill in Mr. Smith that, hey, I don't care what you... Look, here's the deal. You fired off that email before you met with Norm Nichols, okay? You did not fire that email off after you met with Norm Nichols. Now, why would there be such grave concern over when that email, which we know was fired off on December 8th, 2011, why would there be such great concern about clearly establishing that you fired the email off before you had the meeting with Norm Nichols? And that's very simple, because if it is not, it starts to look more and more like the Attorney General's office was right there in with Molina. Remember, the first thing Scott Bailey did when he received the forwarded complaint from Jeffrey Branch, the first thing he did was to call Norm Nichols at Molina, the president of Molina, the company that's going to be out on the street, okay? I said at the outset that was a bizarre action, and I still believe it's a very bizarre action. But that's what he did. In fact, were it not for Norm Nichols, they wouldn't have known how to contact Steve Smith, wouldn't even know who he was. Remember, he's using the alias John Canigo, okay? I wonder how intuitively the Attorney General's office knew to contact Norm Nichols at Molina. Don't guess it could have been because it had that meeting. Don't guess it could have been that once the forwarded email came on, maybe there was a little deal, okay, you've done your part, we'll take it from here? Meaning the Attorney General's office? Sure does look like they're going to great lengths to try to downplay that scenario. Downplay the scenario that the meeting took place before you fired off the email. And I mentioned to you that they were going to hang their hat on a receipt from a Mexican restaurant, and I even gave you a link to one. I just went to Ninfa's again, I think over the weekend, and as you can see, here's a receipt from Ninfa's. You know, I paid for this using a Visa card, all right? It's got the same thing I ordered before. Mom and I are kind of creatures in habit. We had dinner together. But as you can see, this is my copy of my receipt paid for with a Discover card. Do you see my signature anywhere on there? Paid for with a Visa, and it even says Visa. It does tell you that much. Okay, there's not even the last 4 digits on here, and I'm not gonna go out on a limb and say they ate at Ninfa's, but I think it is a very fine restaurant. I think it's a very good chance that's where they ate. And interestingly enough, in his original testimony, Steve Smith said he left this meeting, whether it took place before or after, and he was very emphatic in his original testimony that it took place before, and he said he left afraid. Okay? All right, so that would be why they would go to such great lengths to engage in obvious witness tampering and obvious evidence tampering, that they would go ahead and make the AG's office look utterly, I don't really have the vocabulary to describe how it makes the AG's office look in engaging in this. But the biggest problem here, the reason the evidence tampering is because you got to realize when Judge Kelly looked at the Canigo report, which was compiled by Scott Bailey, supposedly based on information he got from Steve Smith. Steve Smith now says there's a ton of stuff in there I didn't say, and some very critical stuff too, especially about the part about Bobby Jindal with the India to India ancestral relationship that brought President Ahmed of CNSI Jindal and Ahmed together, that presumably wound up maybe creating the CNSI contract. Starts to seem like that might be a potential defense for a jury to say, oh boy, we don't like that. You know, taking jobs away from folk that are here. This is a company from India. I don't know what their motivation is. All I know is it's in there. Steve Smith says he didn't say it. Well, he got in there somehow, and the only 2 people that would have had any involvement in this Canigo report are Steve Smith and Scott Bailey with the Inspector General's office. So having to have an edited version of the Canigo report, again, using the polite words of Mike McKay, assuming one even existed before Steve Smith's deposition, that looks horrible, okay? So when I made that analogy of LSU going up against Appalachian State, and apologize to Appalachian State, I just pulled a team out of the air, that's what I'm referring to when we get on to that civil trial for CNSI. Louis Oglesby and Mike McKay are going to be like the LSU, and they got all of their lineup. They're all good and healthy. And on top of the AG's office basically playing the role of Appalachian State, I think you may find their quarterback's got a torn ACL, starting quarterback. So they probably have to go to the backup quarterback. That's how bad of a route I'm predicting this is going to be in court. Now, could be wrong, but you can start to see, putting the pieces together here, that this doesn't have the makings for a very good outcome for the Attorney General's office, and consequently not a very good outcome for us, the taxpayers. All right, now I told you at the last session that we would move on to the Bruce Greenstein criminal trial, and that's what we're going to delve into today. As I mentioned, there was a grand jury impaneled in May of 2013 to pursue what the AG's office would believe would be criminal activity. And bear in mind, there's a lot of pressure on the AG now to come up with something, because he done marched in there and told Governor Jindal, you better cancel this contract, all right? And Jindal said, okay, AG's office says we better cancel it. And, that goes back to what I had said in the very first episode for those of you who may have missed it or did not go back and look at it, or maybe it's the second episode, I can't remember. But anyway, it is a known fact that Bobby Jindal, their modus operandi, when they find out that somebody's bringing attention to them, they don't take time to sort out who's right, who's wrong. We got to get this attention directed away from us real fast. Well, the way they did that is they did as the AG suggested. They canceled the contract, and they also terminated Bruce Greenstein. You can say he was allowed to resign, whatever the case. He was going to be out the door, and he was out the door in early May of 2013. Now, Buddy Caldwell's got this grand jury, impaneled, and you have 18 months. You have 18 months, and then the grand jury must be disbanded, okay? So this thing took, this jury was impaneled in May of 2013, so you can do the math. Around November of 2014, it would be mandatory that it would have to be disbanded. All right, well, everybody wonders, okay, what you got, buddy? What you gonna come up with? What you gonna come up with? And all he could come up with, now bear in mind, Bruce Greenstein's been terminated. He's back in Washington, his home state. He just wants to get his whole name back. You know, he's got this huge cloud hanging over him. So Bruce Greenstein agrees to come in and voluntarily testify before the grand jury. Okay, doesn't have to do that, you know. And so, but he wants to come in, clear up anything that there may be hanging over his name. And so the AG's office says, okay, we believe you committed perjury in 5 statements that you made with regard to this grand jury testimony, and also 4 statements that we believe you made way back in 2011 when you were undergoing your confirmation testimony to obtain the DHH secretary position in the first place. Absolutely nothing to do with the awarding of the contract. So 5 of the counts had he not voluntarily come in here, he wouldn't even be hit with. That goes to show you where, you know, no good deed being unpunished. But we're going to provide you with a link for the grand jury testimony that Bruce Greenstein gave, at which Caldwell's office alleges there are 5 accounts of perjury, but I'm just going to tell you, you're welcome to read through it. I think you're going to find it pretty much a joke in terms of the indictment and the accounts in the indictment. I think probably you were dealing with a grand jury that was full of fatigue. The 18 months is strong. Now, this came down in November 2014. It was right before it had to be disbanded. Understandably, there might have been some sentiment that, we're going to get somebody. And I think that, they pretty much said, okay, Mr. Caldwell, if you say it was perjury, it was perjury. Well, there are things in there that just do not make any sense to even be perjury. If someone says, I can't recall the specifics of a conversation that took place 4 years ago, exactly how do you plan to prove he could recall it? Okay? It is a state of mind. Look, I'm going to tell you something. As I get older, I'm 51 now, sometimes I struggle within me to remember somebody's name, and I get so aggravated that I cannot remember it, and a day later, I can tell you what the name was. It's just a fact of life. And I get so angry, because used to, when I was younger, that didn't happen to me. It seems to happen more and more now. But I will try to recall someone's name from, say, 2 weeks ago, and I just struggle. I know everybody watching this has done the same thing. And Bruce Greenstein did answer honestly. He could not recall. Okay? You're not going to be able to substantiate a perjury charge on that. That's how utterly desperate the DA's office is. They also say that he was not candid with regard to text messages that he had sent to gentleman CNSI. And yet, if you read the grand jury transcript, he said they were prolific texters, the 2 of them, and engaged in all kinds of social texts back and forth. How's your daughter fare? How did she fare in the tennis match? Things of this nature. Okay? But he said we're prolific texters. I don't know where that matches. He was not forthright with the number of messages. He said it point blank, prolific, unless you want to say, your definition of prolific texter doesn't match what we believe was the extent that I don't know where the AG's is going with this. I just know it's in my opinion, this is going to be right on a par with the Murphy Painter trial, if this whole thing actually makes it to trial. And that thing was an absolute joke. I mean, the U.S. Attorney's Office, that should meet the Hall of Shame. That case was so pathetic. But we'll and I think that Buddy Caldwell and his office knows it's a pretty pathetic case, that they can't win at trial. So what do? They decide, hey, we're gonna file this grand jury transcript into the public record. That's the way I'm able to give it to you, because it was in the public record, and you're welcome to go in there and to look at it. But if you do that, I would steer your attention toward around page 96 or so, maybe a couple of pages before 96, maybe a couple of pages after 96. But before I get to that, let me just say this. Okay, it's filed into the public record. Okay, an unheard of act and in violation of Louisiana's secrecy laws with regard to grand jury proceedings. Okay, they're not supposed to be made public. All right, not even after an indictment. All right. They're not supposed to be made public, and yet he did this. Okay, well, he had submitted an order on what was on previous a little small procedure in court in late December of 2014. And John McClendon, the defense attorney, he had no reason to believe anything like this was happening. So, the official explanation was it's just a housekeeping measure so that Mr. McClendon can get a copy of the grand jury transcript, something to which he was entitled to anyway as Mr. Greenstein's defense attorney. But kind of in there said, oh, by the way, we're going to file this into the public record. Now, McClendon said that, hey, he didn't have a clue this was in there. It was buried right at the end of the order. How could you do something like this? Okay? As you can see, there's several lawyers not real pleased with the Attorney General's office. We got Louis Unglesby and Mike McKay. How dare you accuse us of witness tampering when you're out here doing the witness tampering? Now we've got, for whatever reason, Buddy Caldwell's desire to get the grand jury transcript into the public record. Well, the real reason was so there would be newspaper articles about it, to the extent that I guess it could be. I mean, there's just nothing there, okay? But it's grasping at straws to try to obtain some. Now, as a result of this having been filed into the public record, John McClendon challenged it and moved to quash the indictments based on the fact that, hey, the grand jury secrecy laws were violated here. Judge Daniel, who is overseeing the criminal trial, did rule that the Attorney General's office acted properly. Mr. McClendon appealed that decision to the First Circuit Court of Appeals, and they rendered their decision. All three of the judges, all three of them, okay, said that, no, this should not have happened. This should not have been filed in the public. In other words, I shouldn't be able to give you a link to that because I shouldn't have it myself, okay? But as Caldwell says, hey, the gate's been opened and we can't close it now. But the important thing is you had three judges, all three of them, who said, this should not have happened. It was a violation of the grand jury secrecy laws for the Attorney General's office to put this into the public record. The only thing the judges disagreed on is two of the three judges said that quashing the counts of the indictment is not the appropriate remedy for the judge having, and we're giving you a link for the First Circuit Court of Appeals ruling. It's just one page, and I've highlighted the material. Now, John Michael Guidry, who was one member of the First Circuit Court of Appeals panel that heard this, he dissented and said, I certainly believe the grand jury secrecy laws were violated, but I believe the appropriate remedy is to quash these counts in the indictment. And so I'm not sure what the other two judges would view as the appropriate remedy. They didn't specify. I can only assume about the only other remedy I know of left is that you would sue the Attorney General's office, which is not going to accomplish very much. But and also, if that's the only remedy you've got, there's nothing to keep the Attorney General's office from doing this again in the future. Fortunately, John McClendon is appealing that case to the Supreme Court, so that'll be interesting to see. That's probably going to take a while to get the ruling on that. But the point is that the AG's office, obviously 3 judges said, hey, you screwed up here, okay? You had no business filing this into the public record. And I kind of believe they knew that what they were doing was improper. Probably didn't figure John McClendon would challenge it, especially not all the way to the Supreme Court. But there was a newspaper article written on that. We'll give you the link for that. And in that, once again, David Caldwell says, hey, we did everything right. We did everything right. It's going to be in a newspaper article that we'll give you a link for. You know, it's mind-boggling that, you know, we did it. If everything is pure as the driven snow for the AG's office, if you let the AG's office do the assessing of itself. But it's far from being the case. If you talk with any informed attorney, I didn't talk with a single one who didn't tell me this wasn't a violation of the grand jury secrecy laws. And you got 3 judges who say this was a violation of the grand jury secrecy laws. And yet somehow David Caldwell can still make that statement, presumably with a straight face, that, hey, we did everything right. You know, I'm not so sure I wouldn't agree with him if you just replace the word right with wrong. Okay, with regard to the whole witness tampering, the evidence tampering, the filing of the grand jury secrecy into the record, the transcript into the record. I think if you change the word from right to wrong, he may be pretty close, okay? Because I could find very little that they've done right in this entire sordid episode. From canceling the contract to the witness tampering to the filing of the grand jury testimony into the public record, you know, tell me where there's something right in that, all right? Now, I mentioned a moment ago that if you are going to take a look at that grand jury testimony, the vast majority is very boring. I've talked to you about some of the counts in there, that are just absolutely laughable. I mean, they are literally laughable. You can see the others in there aren't much more of substance than the one that I've already told you about, which I think, I don't know, a first-year law student I would figure is going to be able to easily defeat that. And John McClendon is far from any, first-year law practitioner, so he too will represent another LSU going into the courtroom. But if you are going to look at the grand jury testimony, I mentioned a moment ago, I would recommend reading maybe no more than from maybe page 94 to 98, just in that little 4-page span. And the reason I say that is because it is very obvious to me that Buddy Caldwell or David Caldwell, acting on behalf of Buddy Caldwell in the office, is not nearly so much on the offensive for Bruce Greenstein as he is trying to, hey, buddy, give me a little help here on this. We are being sued. The state is being sued, and I need a little help. And so he is asking questions with regard to the amendment that took place that some parties, including the AG's office, are contending that without this amendment to the RFP, that's Request for Proposals, and it entailed using a subcontractor. Bear with me, I'm going to have a little bit of water. It entailed using a subcontractor for one particular aspect. And the contention was being made that, well, gee, if you didn't do this, they wouldn't be eligible to bid. And David Caldwell is boldly saying, look, you know the reputation of our state. You know how corrupt it is. You know how it operates. Are you actually going to try to tell me that you didn't make this, put this amendment in here to benefit your former employer? Now, bear in mind, he didn't work there for 14 years. But, and I would submit that David Caldwell ought to know pretty well the corrupt nature of this state. I mean, he may as well have said, hey, Daddy does it. Daddy engages in this sort of thing. Just take a look at this WWL investigative report about how he awards all the contracts to all of his big-time campaign contributors. We're going to give you the link for that little WWL investigative report, all right? I would strongly encourage you to watch it. It's not all that lengthy. So David Caldwell could speak from experience because he said, we practice what I'm telling you. Our office practices what I'm telling you. Yeah, we've gone out and given tons of contracts to our close friends, associates, campaign contributors. So don't sit here and tell me that you weren't trying to do the same type thing and extend some favoritism for the firm you worked at 14 years ago. I mean, it's almost leading witness questions in there, you know. I mean, if you look in those pages, you know, it's basically leading, this is what I need you to tell me, because we have been sued and I need some help. And so basically he's saying, hey, here's this letter of recommendation that was sent out. I told you the letter of recommendation for CNSI that was sent to Arkansas officials, that poses a huge problem in this CNSI civil trial. You know, you send out this glowing letter of recommendation and, you know, 10, 15, 20 days later, you terminated the contract. Don't even tell them why. Send a press release, hey, for cause. That's all we're going to tell you, okay? Here we got this, you know, disgruntled employee that is the source of all of it. You know, so that doesn't look good. And he needs some help. He needs some help from Bruce Greenstein. Help come in, bail him out of this mess that he's gotten us, his office in, everybody in on this CNSI civil trial. And Bruce Greenstein didn't give him any help, okay? He just said, look, this didn't cause them to get the contract, okay? Anybody else could have used subcontractor too. And I guess lost in that is the fact that, hey, these people are $45 million, I believe I'm under on that, but approximately $45 million below the next highest or lowest bidder, okay? Well, apparently that means, hey, look, the way it works in this state is you got to get the person that we want getting the contract, okay? Starting to look an awful lot like we now may have a clue why they picked up the phone and called Molina. They called Norm Nichols at Molina. It's starting to look like Louis Oglesby was on to something when he said that, I believe, that's why I repeated it twice. That's why I repeated it at the end of one episode and at the beginning of another. Because Louis Oglesby, a very sharp individual, it looks like he's able to put the pieces of this puzzle together long before John Q. Public's getting a glimpse as to what's going on here. All right. And so, you know, it's starting to look like, hey, and it also behooves, how did this whole India to India? And so, and what role does that play? Okay, aside from, hey, perhaps it'll serve as if we can keep it in as evidence. I don't know how you're going to keep it in now. You know, given that Smith says, I never said that. But my point is, Caldwell he's not on offense. And if Greenstein had given him what he needed, Greenstein, there would have been no indictment. Greenstein didn't give him anything that's going to help in this CNSI defense trial. And I think that Greenstein would say there was nothing to give, okay? You know, Greenstein said, I was trying to expand the maximum level of competition possible in order to cut the best deal that would save taxpayers money. And I'm starting to become convinced that he may as well have been speaking a foreign language to Caldwell because, as I have said, their programmed mentality, as evidenced by that WWL clip, is that, hey, that's not the way things operate in Louisiana, okay? Is it quote pros on anything, all right? Oh, you know, help me out here. Why'd you do this? And Greenstein just holds firm. I did it to expand the competition in order that the taxpayers of this state could reap a huge savings. All right. I'm not going to, there are a couple of things that McClendon has filed for the criminal trial, one of which is saying that the Inspector General's office operated in a loose cannon manner in not getting search warrants. And the reason I'm not going to cover that is because the same identical arguments were made with regard to the Corey Delahousse matter. In fact, a lot of them are almost verbatim situation repeats because in both instances, the Inspector General's office did go in. They didn't follow the proper procedures, didn't have search warrants for getting various items, that didn't have the 24-hour, 48-hour, whatever it is, waiting for a judge to sign off. None of that was adhered to by the Inspector General's office. They too run a pretty loose cannon operation over there. The reason I'm not covering that in any length of detail is because Judge Ricks, who is a judge in 21st Judicial District Court, did in fact say that, hey, y'all didn't follow any. None of this evidence is admissible because the IG's office didn't follow any of it. That case was appealed to the First Circuit Court of Appeals, and the First Circuit Court of Appeals said that Judge Ricks went a little too far. So I think that whole issue has pretty much been resolved. By the way, they did say, however, that the inspector, the whole attorney general's, the district attorney's office over in 21st Judicial District Court, that they didn't have sufficient probable cause for proceeding on with the trial. So I think that whole issue is pretty much dead. However, I do want to make one comment. One of the things in that, although I don't think it's going to be all that relevant now, given the ruling that was made by the First Circuit Court of Appeals with regard to the Corey Delahousse matter. The AG's office argues that, hey, we don't need search warrants, all right? We're talking about somebody's cell phone records, specifically Bruce Greenstein's cell phone records. And I'm just going to give you a link for a Channel 9 investigative report, which does entail Attorney General Buddy Caldwell's office having gone out and procured this a cell tracking mechanism disguising itself as a cell phone tower in which they can get anything they want from your cell phone, okay? Your text messages, things of this nature. And Channel 9 did an excellent job in exposing that. The AG's office had kind of kept all this on the hush-hush that they even had it. They sent, I think, 3 employees to Florida to be trained on how to use it. And this sort of leaked out, and I will say that Kenny Havard, a representative from the Zachary or St. Francisville area, he got a little concerned here, and so he filed a bill in this last legislative session to say that the Attorney General's office would need a warrant to utilize this type of equipment to gain specific access to your cell phone records, the texts, things of this nature. While the AG's office wasn't willing to make a public statement on Havard's bill, Havard said, hey, I think they're going to support it. Well, all I can tell you is it died. It didn't make it out of committee, so there must not have been a whole lot of support for it. But I'm going to tell you one thing right now. I don't know how many of you watched the debate, the first presidential debate. There was an interesting exchange between Rand Paul and Chris Christie. And there was another legislator who, I don't remember his name now, had filed a bill to expand the AG's role in our cell phone records. And I'm just going to repeat what Rand Paul said to whomever that representative is, and his name escapes me right now. But if you want to go and put a big old bear hug around Attorney General and give him, and you've got trust in him with regard to your cell phone, you go right ahead. I don't, okay? Not with everything I've seen from this group, okay? So I commend Representative Havard on his bill. It's unfortunate that it died in committee, and I certainly don't trust that, okay, now look, we got this capability, but we're not going to use it in an improper purpose. Oh, no, not even an AG, not an AG's office that would engage in outrageous witness tampering, that would engage in evidence tampering, that would cancel a contract based on one disgruntled employee's assessment of, and I'm not going to go into all that he said in that Canigo email. But at any rate, no, I don't have any trust in this AG's office. None, zero, nada, okay? None, So I'll wrap this up by, saying that, as I said earlier, if this thing does make it all the way to trial, and I think it would be a travesty if it does, because Bruce Greenstein has been used as nothing but a chess pawn in Buddy Caldwell's defense on the CNSI civil truth. That's all he's serving as here. He is a chess pawn, okay? Welcome to Louisiana politics, Mr. Greenstein. It's a very unfortunate thing, and I think this sends a very, very bad signal for Louisiana if you're trying to recruit top-notch talent. And I think Mr. Greenstein had a resume that indicated he was top-notch. Well, he still is top-notch talent. Unfortunately, he's got this cloud hanging over his head as a result of the corrupt nature, as David Caldwell spelled it out in this state. And in this particular instance, I think that Caldwell is desperately reaching for a defense in the CNSI civil matter, and as I said, David Caldwell is being used in a pawn in it. But I do believe if this thing proceeds on to trial, that it is going to be a joke that is going to be even more laughable than the Murphy Painter trial that I referenced to you earlier. But here's the sad part, okay? If my prediction comes to fruition and Bruce Greenstein is exonerated of the charges, as I certainly feel he will be, now we've got the situation. We had to pay Murphy Painter's defense costs. I don't even want to guess what these defense costs are, okay, because now we got an element of the case going to the Supreme Court all over Caldwell's screw up, but the defense has to pay, okay, on all this. So it's going all the way to the Supreme Court on this whole business of filing the transcript into the record. So we're going to have some pretty staggering defense costs for Bruce Greenstein that we as taxpayers will be responsible for picking up once he's exonerated. The prosecution cost of all this, of retaining a grand jury for all these months, and just the man hours and whatnot, what I think is going to be just an absolute goose chase that's going nowhere. Then we have the millions of added dollars that Molina has been costing us, okay, because they wound up getting to keep the contract by default, okay, once Buddy Caldwell in his office canceled the thing. All right, so we got that added cost. Then we'll have a CNSI civil judgment that we've got to pay. Do you start to see how staggering the cost can be whenever you've got an Attorney General's office that conducts itself in the manner in which this one does? I mean, they add up. They are staggeringly high, okay? Now, there will be a hearing on August the 25th at 1:30. That's one of the reasons I'm getting this video on out. Basically, John McClendon has said some of the things I said early on. You can read the article, but he said, it's not perjury, okay? A person's state of mind he couldn't remember, all right? Talking about prolific texting, where's the perjury there? And so this is just, I would certainly figure at a bare minimum on August the 25th, several of these counts are going to be dropped because, logically, there is no perjury here, okay? And like I said, maybe the grand jury said, okay, Mr. Caldwell, if you say so, perjury, let's get out of here. It's been 18 months, let's go. We'll see how things turn out on August the 25th. In my opinion, it's time to get this circus act over, and let Mr. Greenstein get on with his life and get on with his life. There's going to be some fallout from this, I feel certain, but that's going to wrap up my coverage of Attorney General Buddy Caldwell's office, except for, this is all from outsiders. I'm going to do a fifth segment, and I'll do it in about 2 or 3 weeks. I'm going to take a break because something was just dropped into my lap about 6 days ago. I was not anticipating it, but I'm gonna go to work on it, and it will be a precursor to. It will be, if you will, a lead-in for the fifth segment of the Buddy Caldwell sound-off feature. It's a perfect tie-in. Like I said, I was not expecting it, but 6 days ago today, I got it. It was delivered to me, quite unexpectedly. And so I'm going to use that, and then in about 3 weeks or so, I'll give you my own sound-off feature that won't involve third parties in terms of the Attorney General's office. It'll involve me, okay? And there will be quite a number of names of individuals that will be thrown out who are employed at the Attorney General's office, all of which are the vast, with I think everyone except one I've got video coverage of, okay? So I believe you're going to find installment 5. Now, this is big name people. I'm just a little bitty guy, okay? All right, but I think you're going to find it interesting, all right? And as you can see, the office doesn't really change its operations with a little bitty guy or big guy like Bruce Greenstein. So, and I'm sure Bruce Greenstein would probably say at this point, I'd sure much rather be a little bitty guy than all this mess I'm having to deal with. So look forward to bringing you installment 5. I hope everyone has an enjoyable weekend. And stay tuned and read your local paper after the August 25th hearing on Bruce Greenstein. Let's see how successful John McClendon is on getting at least some of these counts thrown out because of their silliness, in terms of perjury. They're just flat not perjury. That's just all there is to it. Alrighty, folks, I hope you have an enjoyable weekend. Once again, this is Robert Burns. We look forward to bringing you installment 5 after we bring you a very special feature that'll be coming up in about a week or so. Look for installment 5 in about 3 weeks. Thank you so much.